The Constitution of Belarus 1994, Provisions on Treaty. Article 8. The Republic of Belarus shall recognize the supremacy of the generally recognized principles of international law and shall ensure the compliance of laws therewith. The Republic of Belarus, in conformity with the rules of international law, may on a voluntary basis enter interstate formations and withdraw from them. Conclusion of treaties that are contrary to the Constitution shall not be permitted. Article 10. A citizen of the Republic of Belarus shall be guaranteed protection and patronage of the state both in the territory of Belarus and beyond. No one may be deprived of citizenship of the Republic of Belarus or the right to change his citizenship. A citizen of the Republic of Belarus may not be extradited to a foreign state, unless otherwise provided by treaties to which the Republic of Belarus is a party. Acquisition and loss of the citizenship shall be carried out in accordance with the law. Article 11. Foreign nationals and stateless persons in the territory of Belarus shall enjoy the rights and freedoms and execute duties on equal terms with the citizens of the Republic of Belarus, unless otherwise specified by the Constitution, laws, and treaties. Article 18. In its foreign policy, the Republic of Belarus shall proceed from the principles of equality of states, non-use of force or the threat of force, inviolability of frontiers, peaceful settlement of disputes, non-interference in internal affairs, and other generally recognized principles and norms of the international law. The Republic of Belarus aims at making its territory a nuclear-free zone, and the state neutral. Article 84. The President of the Republic of Belarus shall 20. Conduct negotiations and sign international treaties, appoint and recall diplomatic representatives of the Republic of Belarus in foreign countries and at international organizations. Article 97. The House of Representatives shall 2. Consider draft laws, including the guidelines of the domestic and foreign policy of the Republic of Belarus, the military doctrine, ratification and denunciation of international treaties, the fundamental concept and principles of execution of rights, liberties and duties of its citizens, citizenship issues, the status of foreigners and persons without citizenship, the rights of ethnic minorities, the approval of the budget of the Republic and the account on its implementation, the introduction of national taxes and dues, the principles of ownership, the basics of social security, the principles regulating labor and employment, marriage, the family, childhood, maternity, paternity, education, upbringing, culture and public health, environmental protection and the rational utilization of natural resources, determination of the procedure for resolving issues relating to the administrative territorial structure of the state, local self-government, the administration of justice and the status of judges, issues of criminal responsibility and amnesty, declaration of war and conclusion of peace, martial law and a state of emergency, institution of state awards, interpretation of laws. Article 116. Supervision of the constitutionality of enforceable enactments of the state shall be exercised by the Constitutional Court of the Republic of Belarus. The Constitutional Court of the Republic of Belarus shall be formed of 12 judges from among highly qualified specialists in the field of law, who as a rule have a scientific degree. 6 judges of the Constitutional Court shall be appointed by the President of the Republic of Belarus and 6 elected by the Council of the Republic. The chairperson of the Constitutional Court shall be appointed by the President with the consent of the Council of the Republic. The term of the members of the Constitutional Court shall be 11 years, and the permissible age limit shall be 70 years. The Constitutional Court, on the recommendations of the President of the Republic of Belarus, the House of Representatives, the Council of the Republic, the Supreme Court of the Republic of Belarus, the Supreme Economic Court of the Republic of Belarus, the Cabinet of Ministers of the Republic of Belarus shall produce a ruling on the conformity of laws, decrees and edicts of the President, international agreements and other obligations of the Republic of Belarus to the Constitution and other instruments of international law ratified by the Republic of Belarus, the conformity of instruments of interstate formations of which the Republic of Belarus is part. Edicts of the President of the Republic of Belarus which are issued to the execution of the law, the Constitution, the laws, decrees and instruments of international law ratified by the Republic of Belarus. The conformity of the decisions of the Council of Ministers and orders of the Supreme Court, the Supreme Economic Court, Procurator General, to the Constitution, laws and instruments of international law ratified by the Republic of Belarus, laws, decrees and edicts. The conformity of enactments of any other state body to the Constitution, laws and decrees as well as to the laws and instruments of international law ratified by the Republic of Belarus. Enforceable enactments or their particular provisions, which are considered unconstitutional, shall be deemed invalid to the order determined by the law. In instances specified by the Constitution, the Constitutional Court, with regard to the proposal of the President, shall give its conclusion on the presence of instances of systematic or flagrant violation of the Constitution of the Republic of Belarus by the Chambers of Parliament. The competence, organization and procedure governing the activities of the Constitutional Court shall be determined by the law.